Welcome, and thank you for coming to this webinar on capacity, homelessness and social care, the first of two that Katharine and I are planning and doing over the next couple of weeks. Second, we'll focus on managing money. We are delighted, and at least for my part, a little bit amazed to see so many of you joining the session today. And we hope that you find what we're going to say useful and informative. So my name is Justin Bates. I'm a KC here at Landmark Chambers. I am chairing the session today, and I'll be talking about homelessness. And then I'll be joined by my colleague, Katharine, Elliot, who you can also see on the screen, who I'll introduce in a moment. A little bit of housekeeping first. Your microphones are all automatically muted, so you don't need to adjust your settings on your computer. We are very keen to have questions throughout the session, and the best way to deal with them, if it's all right with all of you, is to type them into the Q&A text box, which should be found at the top or the bottom of your screen. It moved for me. If you want to remain anonymous when you ask a question, then just make sure you tick the send anonymous box before submitting your question. We will try and answer as many questions as we can at the end of the presentation. The webinar is being recorded, and you'll receive a link to the presentation and the recording in due course. And if at any stage you lose connection during this webinar, then rejoin by clicking on the original link. In terms of a little bit of introduction to us first, Katharine is a public law junior here at Landmark who advises and represents individuals, local authorities, government departments, and other public bodies across a very wide range of sectors, including court protection, education, health and social care, mental health, immigration, inquests, and inquiry work. She appears as both sole and junior counsel in the High Court and the Upper Tribunals and the Court of Appeal, and was recently appointed to the Attorney General's B panel of counsel. I am a housing lawyer. I'm the editor of the Encyclopedia of Housing Law. I most recently worked on the capacity-adjacent legislation of the Supported Housing Regulatory Oversight Act, and these days I spend most of my time in the High Court, Court of Appeal or Supreme Court dealing with housing law cases. This presentation today stems from a talk that we did for Oxford City Council a few months ago. And I assume it went well because they gave us very nice cake afterwards. So I thought we'd repeat it here, but there is no need for any of you to send us cake through the post. The plan for Katharine to do an introduction to capacity law, and then I'll do homelessness. She'll come in then after that with social care issues, and then we'll pick up with the Q&A towards the end. And if you like this webinar, there will be another one, I think next month, it's in the diary, about managing money and capacity issues. So it would be nice to see you then as well. But I think that's probably enough there. So if we can, where have our slides gone?
I can still see them, Justin. So have you banished them?
Oh, my slides have vanished. I can't see mine still. So as you're speaking first, do you want to take over? And maybe maybe they'll turn up on my screen again at some stage.
I'll keep my fingers crossed for you, Justin, and get stuck in on mental capacity law. Welcome, everyone. Good afternoon. Thank you for joining us. It's lovely to see so many familiar names on the list of attendees. And also, if you're coming to us for the first time on this area of law, welcome to you as well. So an introduction on mental capacity. I know there are lots of very experienced COP practitioners on this call, but I think that it is good for all of us who work in this area to regularly refresh our brains on the framework because notwithstanding our experience, even the best of us can come unstuck sometimes, especially when a judge is talking to us about assessments. So the starting point, wherever you are in the law, is the presumption of capacity. So someone has capacity to make decisions for themselves until such time as it is proved by evidence on the balance of probabilities that they do not have that capacity. So that's really important. And we'll come back to a lot of themes within that sentence through the next couple of slides. So what's the test? The test is that someone lacks capacity if at the material time, put a pin in that, they're unable to make a decision, put a pin in that, because of an impairment of or a disturbance in the functioning of the mind or the brain. So what were those two pins I stuck into that sentence? The first is at the material time. So capacity is time specific. So you want to know what someone's capacity is at the time of the relevant decision. In the sort of homelessness and care context, it will be at the time that they are being asked to make the decision for themselves. And obviously capacity can change over time. And the second pin was to make the decision. So capacity is decision or issue specific. So someone can have capacity to make some decisions and not others. They can also have capacity to make decisions that are more limited within a general sphere. So they might not be able to make a decision about, should I make a homelessness application, but they might have capacity around what would I like my property to look like, so suitability. So those are two very important things to remember when you are either assessing or where you are evaluating an assessment from a legal perspective. Inability to make a decision can mean a lot of different things, but it's a combination of inability to understand or to retain or to use or weigh relevant information about a decision, including the foreseeable consequences of deciding one way or another, or an inability to communicate that decision. So I'm doing several cases at the moment which involve people who have been deaf since birth, who were trained at some point to communicate via BSL, but that has been lost over time or significantly weakened. And so a big issue in those cases is how much they're not communicating a decision or communicating inconsistently is because of that communication problem, or whether it's an understanding, retention, use or weighing situation. So all of those things, and anyone who's dealt with assessments will have seen them, all of those are in the alternative. So you can have inability to understand and also inability to retain, or you can have everything except one of those. And in which case, if one of them falls away, you don't have capacity under the Mental Capacity Act. As I've said, it's established on the balance of probabilities. Sometimes the evidence will be incredibly clear, sometimes it will be conflicting. And obviously, when it's conflicting, you normally end up in the court getting a judge to decide. So a very important thing that's come up in recent cases is that there has to be a causative link between the impairment of or a disturbance in the functioning of the mind or brain and the inability to make the decision. And I've put on the slide here a very helpful recent case called ZX. Now, ZX was a capacity to make decisions about sex case. Briefly, the protected party had a diagnosis of ADHD, and he had committed what would, if he would definitely capacitous, be considered criminal offences, so sexually assaulting other young people and children. And the question was, does he lack capacity to control his impulses around those acts because of his ADHD? Or is he someone who has ADHD who just makes bad decisions about committing criminal offences? And in that case, the lower court found that the ADHD was the cause of his inability to not offend. But the Court of Appeal overturned that and said, look, there has to be clear evidence that the ADHD is causing him to make bad choices because he doesn't understand that that's what they are. But in reality, in that case, there was no such evidence, and you couldn't say someone has a diagnosis that is an impairment or a disturbance, and then automatically say, therefore, everything they do that's unwise is because of that. There has to be a causative link. As I've said, lack of capacity can be permanent, temporary, or fluctuating. Fluctuating capacity cases are incredibly difficult and require a lot of careful thought in terms of care and support planning. It has to be based on relevant evidence and not on assumptions based on age, appearance, or presentation. And I think presentation is particularly important. Most people understand about the age and appearance, but I've seen recently cases where assessors have taken into account physical tics or speech slurring, which is caused by a physical impairment, and have interpreted it as being some sort of cognitive impairment. So presentation really is something that everyone working in this field should be cautious of when they're encountering protected parties, especially if they're meeting them for the first time and they're not familiar with that presentation and how it is for someone in their normal life. Before assessing, you must have taken all practicable steps to support autonomous decision making, including communicating the relevant information appropriately. Now, this is something that quite often local authorities can get in difficulty with, especially around urgent cases. Now, obviously, what you need to have done before carrying out an assessment and coming to the Court of Protection depends on the facts. But if you're not dealing with an urgent case, you are expected to record in your assessment and in your evidence what you've done to try and support someone to make a decision by themselves, normally, but not always, as part of the assessment. So going back to the BSL cases I mentioned earlier in the talk, that would be making sure that you have a BSL interpreter or a deaf relay or both with you, explaining that you've tried using visual aids and that you've tried to familiarize yourself with someone's communication over time to make sure that you're sharing relevant information about the decision and assessing their ability to understand it appropriately. And then the last point on this slide, and a very important theme that the court is always stressing these days, an unwise decision is not the same as an incapacitous one. So going back to the case of RZX, he was obviously making very poor decisions, not just for himself, but for the people that he was assaulting. But that didn't mean that he lacked capacity, even though he had ADHD and his own vulnerabilities. So that's broadly around capacity assessment. So that, I think, is the first half of what mental capacity law is about. The second half is about best interests. So Section 48 of the Mental Capacity Act, so the legislation that sets out all those tests I've been talking about, says that the threshold for the Court of Protection to have jurisdiction and be able to start making decisions is when there is evidence to call into question capacity. So you've not established it on the balance of probabilities necessarily. You might still need further evidence about capacity from experts or from other people, but this gets you into the Court of Protection if you have enough to satisfy this threshold. Now, important second point on the slide, particularly given that we're in a homelessness context here, is that the majority of individuals who are dealt with under the Mental Health Act are excluded from best interests decisions and treatment by the Court of Protection under the Mental Capacity Act, because Parliament has said there are two different ways of dealing with those people and authorising them being kept somewhere potentially against their will. So fundamentally, the Court of Protection is a best interest jurisdiction. That means that its overriding objective is to achieve what is in the best interest of the protected party if it's established that they can't make decisions for themselves. And part of that is the aim to achieve the least restrictive option. So when you're looking at best interest, you should always set out, and many people on this will be familiar, your checklist of options. So your balancing of this is this solution, this is the restriction, this is why the restrictions are good, these are the downsides for P, that sort of exercise. And that is your aim again. So best interest and the least restrictive option. Again, best interest has to be evidence-based and not rely on assumptions. I think a big theme of this recently, in my experience, has been cultural assumptions, with local authorities coming to a situation without understanding necessarily the particular cultural framework the protected party has lived and grown up in and been supported in, and that has caused problems when the court comes to consider it and when the local authority is making care and support proposals, for example, around placement's ability to cater to dietary requirements and the sex of support workers and so on. When you're looking at best interest factors and you're doing that balancing exercise, Section 4 of the MCA sets out a list of checklist factors that anyone making a best interest decision should look at. And that includes whether capacity can be regained. So, for example, if someone has alcohol-acquired brain damage, is there a possibility that if they are sober and don't consume alcohol, they might regain capacity? And I've seen that happen in cases. Past and present wishes and feelings but benefit beliefs and values. So going back to the example I've just given about different cultures and the views of those with a sufficient interest in the protected party's life. So that is normally carers and family members, partners, siblings, children. And very importantly, even if you are in dispute with those people about best interests, you have to take into consideration what they say, even if that's just recording it in evidence and explaining why you disagree. Again, importantly, in the homelessness context, any situation giving rise to a deprivation of liberty. So normally when you're taking someone and putting them in a placement with a package of care and support must be authorised by the Court of Protection under the Mental Capacity Act if it's to be lawful. So you've got the two different frameworks there. So Section 4A taken together with Schedule A1, if it's someone in a nursing or care home, a hospital or care home, and then Section 16 for everyone else. So, for example, people in supported living placements, If you don't get that authorization, you are potentially in breach of their human rights, Article 5, freedom from unlawful detention. And the test for deprivation of liberty is very famously set out in the Cheshire West Supreme Court case and can be summarised as that person is under continuous supervision and control and not free to leave. Now, just to flag here that the Supreme Court will, for the first time in over 10 years, be revisiting that test in a reference case from Northern Ireland, which is due to be heard in October 2025. And the context of that case is that Northern Ireland is considering reintroducing a concept of valid consent without capacity. So there won't be a deprivation of liberty if there's no objection to the restriction. Now, obviously, lots of Section 21A proceedings are brought because someone raises an objection. I don't want to be in this placement anymore. I want to go home. And that's not the threshold test. Everyone's deprivation has to be authorised under the current Cheshire West test, even if they do not object, potentially because they can't. But this would be a return to the pre-Cheshire West position. There's been a lot of domestic criticism of the Cheshire West case because Section 21A proceedings in particular take a lot of time from all involved in the sector, both health and social care. There was some discussion in this country about the LPS, liberty protection safeguards, coming in to try and deal with that, and they haven't been taken forward. So suffice it to say, there's a lot of interest in that case, and a lot of people have applied successfully to intervene. So watch that space in October. The tools of the Court of Protection, drawing this part of the talk to a close. Section 15 declarations, so that is a declaration that someone lacks capacity. It's also a declaration that something has been done or can be done in someone's best interests. It can be retrospective. So if you've been in an urgent situation and you've moved someone to a placement that does deprive them of their liberty without being authorised in advance, the court can retrospectively authorise that, even though it always prefers to do it prospectively before a move. And then the second part of the toolkit is Section 16 best interest decisions. So that is the court making a decision on behalf of someone. So that sort of more prospective side of saying that something can be done in someone's best interests. And they can be very small decisions, like it's in the best interest of someone to have their tenancy agreement terminated or to be moved to a specific place. It can also be to appoint deputies to make those decisions rather than the court. And then finally, Mental Capacity Act 2005 is supplemented by a statutory code of practice, which you have to have regard to when you're making these decisions. I checked out of interest, and for those colleagues who are here from a homelessness perspective, there's only one reference to homelessness in the code of practice, which is about the use of independent mental capacity advocates. So it's not particularly illuminating in that respect. So that was very much a whistle-stop tour through the Mental Capacity Act framework, capacity and best interests. And I'll now hand over to Justin to talk about capacity and homelessness.
Thank you very much. Right. So I'm going to break this down into a couple of stages. Firstly, I am going to, oops, gone too far, come back. I'm going to tell you what the traditional view is on how capacity plays out in homelessness cases. Then I'm going to query whether that's right still, given some of the recent developments in the case law. And then I want to touch upon some of the differences that seem to be developing between England and Wales. And I do that because I'm not sure if they are substantive differences resulting from difference in legal structure, because there isn't that much difference between underlying homelessness law, not at the moment, there may be soon, but at the moment it isn't that different, or whether the Welsh Code of Guidance is wrong, which I think might also be an answer on this one. So the traditional view on applications by people who lack capacity is that they can't apply for homelessness assistance under what's now Part 7 of the Housing Act 1996 or Part 2 of the Housing Wales Act 2014. And that's a result of a case called Garlick in the House of Lords in 1993. And what that holds in substance is that there is an implied limitation in what's now Section 184 or Section 62 in Wales, that an application for homelessness assistance can only be made by someone with capacity to do so. So Garlick is actually it's actually three conjoined cases. And the one you care about for capacity purposes is the third of the three, which is Tower Hamlets and Begum. But you won't find it if you search for that in Westlaw. You need to search for Garlick and then read the third case in that list. What had happened in Tower Hamlets and Begum is that the father had applied for homeless assistance, and the local authority finds him to be intentionally homeless, and he doesn't challenge that decision. So what he does instead is have his daughter apply, because he says, she is not a party to the thing that I did that made me intentionally homeless, so she can apply, and then I will be accommodated as a member of her household with whom she might reasonably be expected to reside. She's 23, so there's no age issue here, but there is a capacity issue. The judgment doesn't go into a vast amount of detail, and some of the language is frankly quite outdated and offensive now, but the gist of it is that she's clearly got some significant mental challenges. She can't speak, for example, and she can communicate only with a special sign language that only members of her family understand. So she applies. Well, local authorities say, we agree that you can't possibly be tainted with the things that your father did that made him intentionally homeless. And that's because you just lack the capacity to be associated with the things he was doing that made him intentionally homeless. But the quid pro quo of that is that you don't have the capacity to apply at all. And what they say is, because you lack capacity, you do not have the right to make an application under Part 7, as it is now, the 85 Act as it was then. And the Supreme Court, as we'll see in a minute on the next slide, uphold that decision. Now, just pause here for a minute and note something in the back of your brains, because this is going to come back in a minute. The Court of Appeal in Tower Hamlets and Begum had come to a completely different view. What they'd said is that there's no reason why a person lacking capacity couldn't have an agent apply on their behalf. And it could even be a good-natured family member acting in the bona fide best interest of the homeless person and trying to help them as best they can. And one member of the House of Lords agrees with that, but 4 of them reject it. And they reject it for these reasons here over the page. And it's worth looking at both of these 2 quotes from the judgment, because this is the gist of the reasoning. So the first reason is that as the Housing Act 1985, which is what was governing homelessness at the time, said, the duty under the Act is a duty to make an offer of permanent accommodation. It's to do with the provision of bricks and mortar and not care and attention for the gravely disabled, which is provided for in other legislation. Then, of course, National Assistance Act, now probably Care Act. So the first bit of the reasoning is that homelessness law is only about getting people into the situation where they're offered permanent accommodation. So just hold that in your mind as well. Second reason, said the House of Lords, is that there is no purpose in making an offer of accommodation to a person so disabled that he is unable to comprehend or evaluate the offer. In my view, it's implicit in the provisions of the Act, that's why I said there's an implied limitation, that the duty to make an offer is only owed to those who have the capacity to understand and respond to such an offer, and if they accept it, to undertake the responsibilities that will be involved. So what Garlick comes down to is 2 points. Firstly, it's actually not about capacity to apply. The point is, if you don't have capacity to understand the offer and to understand what's included in the obligations that come with a tenancy, then you can't apply. So it's not that you can't apply, it's that because you can't access the things at the end of the process, that's why you can't apply. Now, is that still right? Well, the Court of Appeal had another look at this in 2018 in a case called WB and W Council. This is a really messy case. So WB had capacity when she applied initially. She's found to be intentionally homeless, though, and she challenges that in the usual way, Section 202 reviews and 204 appeals. During the course of her 204 appeal, she loses capacity. And so the county court judge, dealing with the Section 204 appeal, dismisses it because he says, having lost capacity, you cannot therefore now understand any offer that would be made to you. So applying garlic, you couldn't have applied in the first place, so I'm going to dismiss your appeal. And that's what went up to the Court of Appeal. The Court of Appeal tell us that garlic means what I've set out there, that a vulnerable person could not herself apply if she could not comprehend or evaluate the offer of accommodation or undertake the responsibilities involved in being a tenant. So that's what I took from garlic earlier. And the Court of Appeal, by a majority of 2-1, say that's still right. One of them, or Justice Lewison, suggests that might be wrong. And he says, well, hang on. Garlic is pre-Human Rights Act, among other things. And we now have an interpretive obligation as courts to try to interpret all legislation in a way that's human rights compliant. Why isn't it human rights compliant to say that she might not be able to apply on her own, but an agent could apply for her? And he says, well, my obligation when I'm interpreting legislation so as to be human rights compliant is to interpret it insofar as it's possible to interpret it that way. It must be possible to interpret it on the basis that an agent could apply on someone's behalf. And I know it's possible because 3 judges in the Court of Appeal said that before the House of Lords overturned them in Begum. And one of the House of Lords said that in Begum. So why isn't that the answer going forward? Now, ultimately, where the Court of Appeal got to is that they said the answer is to apply to the Court of Protection to have a deputy appointed on behalf of that individual person to have them pursue the application. So that appears to be where we've got to for the moment. People who lack capacity to understand an offer and to understand the obligations of being a tenant can't apply. If they want to go down the homelessness route and not, for example, the Care Act route, you need a Mental Capacity Act deputy appointed to do it for them. But I'm really not sure that is right. And now I move into stuff that I think is much more exciting. You'll remember that the first reason the House of Lords gave in garlic as to why there must be an implied limitation on who could apply is that the point of what was then part, whatever it was, of the Housing Act 1985 was that your homelessness applications got resolved by an offer of permanent accommodation. But that's not right anymore. It used to be the case, I agree, in both the Housing Homeless Persons Act 1977 and then its reenactment in the Housing Act 1985, that you applied and you got a council house or you got nothing. But that's not how it works anymore, as we know. You might get a council house, you might get a housing association house, you might get a private sector tenancy, you might get no tenancy at all. You might merely get advice and assistance. You might get an assessment under both the English and Welsh assessment duties, and then support to keep you in your current accommodation. You might get the off-ramp of a 6-month assured short-hold tenancy to bring it to an end. You can hardly describe that as permanent accommodation. And so I wonder if that first part of their reasoning is still right. Homelessness law nowadays isn't necessarily or inexorably about getting permanent accommodation. It's about getting assistance with your homelessness. So is that first reason right? Are the assessment duties owed to people who lack capacity, regardless as to whether more substantive duties are owed? So, for example, could 189A and 189B be owed, but not 1932? The Welsh Code of Guidance appears to agree with that. And I know the Welsh Code of Guidance isn't binding in England, but A, we have some Welsh people here on this, and B, the Welsh assessment duties are pretty similar to what we've got under the Reduction Act. Indeed, the Welsh legislation was the inspiration for much of the Reduction Act. The Welsh Code of Guidance at paragraph 3.149 tells us that when we're doing our assessments, i.e. what's in England are 189A assessments and 189B assessments, that the assessment should include capacity. So if that's right, is garlic now wrong? Or at least does garlic need to be reconsidered? Is the true position now that you have to accept the application, at least for the purposes of carrying out the initial assessments in both England and Wales. And then if they have no capacity to deal with the outcome of it, take it no further. I also wonder, frankly, whether garlic is still right, given the way that we approach mental health has moved on, and the issue-specific approach to capacity that Katharine was talking about. Is there not a difference between deciding where to live and understanding the terms of the tenancy? And finally, what about revisiting this agency point? Because Lord Justice Lewison would have allowed anyone to apply on behalf of the mentally incapacitous person. Interestingly, the Welsh Code of Guidance appears to agree. The Welsh Code of Guidance appears to suggest that any agent is enough to permit an application. So I do query whether garlic is quite the answer that most people tell you that it is, and that the Court of Appeals thought it was in WB. I do wonder if it's now rather more complicated, because homelessness law is now more complicated, and whether it depends upon what stage of the process you're at. But for present purposes, you do have decisions of the House of Lords and the Court of Appeal, which say that a person who lacks the capacity to understand the outcome of their process effectively can't even apply in the first place. I just query whether that's still right. And is there any other way around this? Well, firstly, a person without capacity can still nonetheless fall within Part 7 and the homelessness duties, because they could be part of the household of the person who is actually applying. So the other way around to Begum in Garlic. In Begum, it's the incapacitous daughter who applies so the father can get in. There's no reason why the father couldn't have applied, and then the incapacitous daughter gets considered as part of his application. We know that must be possible because A, the House of Lords said so in Garlic. It's one of the scenarios where they say capacity wouldn't matter. But B, that's a priority need category, of course, in both England and Wales. A person with whom the applicant resides, who has a priority need by virtue of mental capacity problems, would obviously trigger a priority need category. So it must be possible to have an application from someone who has capacity, but whose household includes someone who doesn't have capacity. So how do you deal with that? How do you deal with that at the assessment stage? How do you deal with that on discharge? Suitability looks like an absolute nightmare there, potentially. Of course, and this is one of the few bits that the Code of Guidance in England actually goes into and deals with capacity. You also need, when you're dealing with intentional homelessness, to ask yourself whether the act or omission in question was done at a time when they lacked capacity, because it's very hard to see how you could hold that act or omission against them for the purposes of making an IH assessment if they did indeed lack capacity when they did it. Thirdly, what I think is much more difficult, is what happens where the application is made at a time where the person has capacity and then they lose it. Now, you might say, well, hang on, that's the facts of WB. And in WB, what happened was the Section 204 appeal got dismissed and the Court of Appeal said by a majority that was right. But suppose it hasn't got as far as 204 stage. Suppose the authority has accepted the 1932 duty, so they've got the main duty to rehouse, and then the person loses capacity. Where in the Act does it say that applications end in those circumstances? It doesn't. Why does an otherwise valid application suddenly die when that event occurs? And should it die when that event occurs? Because as Katharine pointed out 15 minutes ago, capacity is one of those things that fluctuates. Why can't the person reclaim the benefit of their earlier 1932 decision at a time when they then have capacity again? And finally, and then just leaving you with it from here, because this one is uppermost in my mind because I was fighting about this last Tuesday in the Court of Appeal. I think it's more important in most homelessness cases to bear in mind the difference between capacity and disability. There are plenty of people who have a relevant disability, which is not so serious as to amount to a lack of capacity. It's really a Quality Act, not Mental Capacity Act issues. What do you need to do in respect of the people who have a disability which relates to intellectual understanding, for example? Do you have simple language versions of all of your forms? Do you have provisions in place to identify intermediaries to assist with, for example, explaining why someone should accept an offer and then go for a review, or explaining what the purpose of these questions are and why we're trying to find out why you lost your last home? I think that is, in many cases, the more important and the more common issue to grapple with. But as I say, the law is presently garlic. I'm not convinced garlic is necessarily entirely the answer to everything, but I shall stop there now and let Katharine come back in with some social care.
Thanks, Justin. I, for one, find the inconsistency in how capacity is treated in the Garlic line of authorities with how the Court of Protection approaches capacity on a daily basis now very difficult to reconcile. And so hopefully we'll have a test case at some point that will answer all the questions, ideally with you and me in it. Okay, but moving on then, and picking up on some of the themes that Justin touched on, we're looking at capacity and social care. And obviously, this is a huge field. So I've tried to choose two questions that might overlap for the majority of people attending this, and particularly the homelessness sort of side of things. So the first question is, what should a local authority do in Care Act cases involving alcohol and drug abuse related capacity issues? So very often we are confronted with cases where we have someone who has put themselves in a very bad situation because of alcohol and drug abuse related issues. So they might be discovered by social services living in a property that's in very bad condition. They might have neglected their physical health. They are identified as being in urgent need of care and support to make sure effectively that they don't die from neglect, and they are put in a placement. That's all great. They recover, and then they start consuming alcohol again. And the concern of the local authority was obviously we've worked really hard to secure this placement for them. They've stabilised, they're in a much better place than they were when we found them. What do we do next? And very often you end up in the Court of Protection. Now, the key takeaway from cases involving alcohol and drug abuse by P is that the case is not solely then about capacity to consume whatever the substance is. And that was made very clear in the 2020 case of Tower Hamlets. Now, that was a case where P had a long history of alcoholism resulting in alcohol-acquired brain damage. And very fittingly for this webinar, he became homeless and hospitalised, following which he was accommodated as part of discharge planning in a specialist supported living placement with a package of care including alcohol restrictions. So for a while, as usual, everything was fine, but then he started drinking again, and then that led to antisocial and violent behaviour, which resulted in that placement breaking down, and he became homeless. Now, the local authority basically said to the Court of Appeal, look, he doesn't have capacity because he's unable to understand that if he does this, he will lose his placement and then he'll be back in the homelessness situation he was in before. So please find that he doesn't have capacity so we can continue to try and help him. Now, what the court said in Tower Hamlets was very clearly, you focus too much on the alcohol. It's actually about all the other decisions he has to make as part of his daily life. So about residence, so the placement, care and support, and medication. And there are in other cases, things like contact with others can arise. So it's about those domains and the impact that alcohol has on that capacity. So just because when someone gets drunk, they make bad decisions or unwise decisions, doesn't mean that they don't have capacity under the Mental Capacity Act. We all, without going into too many examples or any examples, make bad decisions when we are drunk. But we wouldn't be happy if we were told, well, you climbed that thing when you shouldn't have done, and therefore you lacked capacity. You're just a person with capacity under the influence of alcohol. So what you have to assess is, does the protected party understand the impact that consuming the substance will have on their life? So, for example, that it might lead to them being antisocial, it might lead to them being made homeless because their placement breaks down, but explain why they keep doing it anyway. So in the case of Tower Hamlets, He knew that if he kept drinking and doing what he'd been doing, that he would potentially be homeless, but he was able to cogently and coherently explain that for him, he felt he was able to control his alcohol consumption and that it wasn't a problem anyway. So he was making informed, unwise decisions under the influence of alcohol. So in that case, he did have capacity. Now, obviously, capacity might be fluctuating around substance consumption. So, for some people, if they have brain alcohol-acquired brain damage, that can get better, can also get worse again. So there's that to take into consideration. But the focus has to be mostly on the other decision-making abilities, not just on the alcohol. It's not just they have capacity around alcohol or they don't, and that's it. You have to assess everything. And the court in Tower Hamlets made one point over and over again that local authorities have to avoid taking what's called the cotton wool approach. So that idea that someone is vulnerable, therefore we should wrap them up in cotton wool to protect them, even if that means depriving them of their liberty. And the court understood where the local authority was coming from, and certainly my local authority clients, including those who are on this call, will understand the frustration that someone is going to be back in a horrible situation, potentially very close to death, if not dying, because of their decision, and the local authority feels powerless. But effectively, what they say in Tower Hamlets, the court, is that is a fact of autonomous decision making, that it can lead to bad decisions and it can lead to very bad outcomes, including death. And if the protected party understands that but does it anyway, that's their choice. Obviously, the flip side of that is that it's very important that local authorities properly approach this and everyone involved in any of these cases to make sure that someone does have capacity before they get allowed to make these decisions because of the risks later down the line for P and everyone else. So can also have in these cases mixed capacity. So capacity by some people around maybe care and support, but not residents. Maybe they're fine with everything except contact with others because when they go out and get drunk, they give their money to people that they don't know, or they can be coerced into crimes. So the courts are increasingly aware of what I call the mixed capacity approach. So where you have to do your social care planning around supporting people's non-capacitous areas, so things like contact, while also allowing them to exercise their autonomous decision making. So protection, but not in the areas where they have capacity, which is incredibly difficult. And I think lots of local authorities are definitely grappling with that, as are, people acting instructed by the official solicitor to try and see what's possible in the real world. And then also on their capacity promoting care planning. So I've done cases where part of what the package that the court authorises involves education around drug and alcohol to try and help someone understand, if they don't have capacity, what happens to them when they take drugs and alcohol. So that's something else that the Court of Protection is increasingly expecting to see when it's looking at a case. And then the second area that I thought I'd flag is the difference between social services responsibility for accommodation under the Care Act and local housing authorities' responsibilities under the Housing Act, which Justin's obviously explained in the context of his part of the talk. Now, this isn't strictly about capacity, but I wanted to put it in here because it is an important tool for social services to work out who's responsible in different cases. And Justin and I have experienced a lot of cases of disagreement about this. So this is the case of Campbell in the Court of Appeal, which involved two of our colleagues, Galena Ward and Sean McGibbon, in 2024. And it was basically about whose duty is it to sort out the accommodation of a vulnerable person. So the background facts are an individual who is assessed with needs under the the Care Act 2014, but not accommodation needs. And I've put there the test on the slide for when accommodation could be a care need, effectively if it's needed to deliver the rest of the care and support package. And that was what happened in the Tower Hamlets case we talked about on the previous slide. He had capacity. He had funded accommodation from the local authority in the past under Section 19, so the discretionary power to meet need were urgent under the Care Act. Because he was at risk of homelessness pending the full assessment of his needs under Section 9, social services tried to support him to access suitable social housing via the Housing Act, but he declined that support. And he also repeatedly declined to accept his care and support package and to complete his direct payment agreement. So effectively, he wasn't receiving anything that he was entitled to under the Care Act, and he was not allowing anyone to help him with his Housing Act things. He wasn't offered a suitable property via social housing. The local authority finished its Care Act assessment and said we can't continue to fund under Section 19, and that funding was pulled. And that is what the case focused on. And it was said basically, well, he has these needs and he's at risk of homelessness. So local authority, you should put back the funding, the Section 19 funding, until such time as he gets his accommodation under the Housing Act. And the local authority raised as a defence to that the exclusion in Section 23 of the Care Act 2014, which says that a local authority may not meet needs by doing anything which it or another local authority is required to do under the Housing Act 1996. And basically, what the High Court said is what that means, Section 23, is that if accommodation is not a care need, so if it doesn't meet that test at the top of the slide, then there is no ability for social services to be made to sort it out, accommodation, to stop someone from being homeless under the Care Act. The responsibility for accommodation in homelessness is social housing, not social services. And it referred back to a case called Idolo, which had made that point previously. And effectively, what the reason is under that is that there are more than two, but in this case, two tracks for getting accommodation which are open. If you have a Care Act need, it goes under the Care Act. If you don't have a Care Act need, it's under the Housing Act, which does reflect priority categories, as Justin said, which might include the fact that you have needs under the Care Act. But you can't use the Care Act to basically fast track yourself into accommodation, which you need because you might be homeless for other needs. That's not how it works. That messes up, basically, to put it in layman's terms, the system that Parliament has designed, which is that homelessness goes this way, Care Act accommodation needs goes this way. There's different responsibilities, different lines of funding, and you can't mix the two together. And the Court of Appeal upheld that decision, emphasising in particular that if it were otherwise, local authority budgets would be a complete mess, and social workers would be made to be housing officers, which they're not. That's not their job. So that was what was decided in Campbell. Now, would the legal position under the Care Act have been different in respect of Section 23 if C had lacked capacity? And the answer is no. That doesn't make any difference. Obviously, it would have changed the facts on assessment of his needs, but it wouldn't change what Section 23 means in practice. However, for all the reasons Justin's outlined, you have to consider whether different practical steps would have been required, not just under the Care Act as I put on the slide, but also under the Housing Act to reflect that this person wouldn't have had capacity to make various decisions. So while not strictly just about capacity, I think a very important case for everyone on this call from a social services and a housing perspective to be aware of. And we're now in the Q&A portion of the talk. So Justin will reappear from the dark screen. And does anyone have any questions? I think I saw potentially some hands up.
We have two that have come in already. One for you, and then I think one for me. In fact, more of them are coming along. First one for you. In Tower Hamlets, was the impact of alcohol classed as relevant information for decisions re-residential care?
It wasn't specified in the judgment expressly, but I imagine that it was because that would have been part of your relevant information comes from the sort of factual matrix of the situation. So if one of the issues is alcohol consumption is not allowed in a placement, and if you do it, your placement might be terminated, or it will be terminated if you behave badly and you behave badly when there's alcohol, then yes, it would be part of the relevant information.
And then I've had one in about people who were evicted from accommodation multiple times because of their behaviour, e.g. alcoholics who you find to be intentionally homeless. So look, the fact that you lack capacity when you do the thing that made you intentionally homeless must be relevant to whether or not it is the kind of thing that should be held against you. Um, it's the whole, you disregard things that were reasonable, even if they were reasonable, even if they were reasonable but daft. I don't see how you can possibly say that someone is intentionally homeless because they punched their landlord, let's say, but at the time that they punched their landlord, they were suffering from a psychotic event that meant they had no control over what they were doing. Intentionality is there to visit people with the consequences of their freely made decisions. It's not to punish people for having things they can't control. The really difficult one, I think, with intentionality is the evidence on it. The Getting the evidence to show that they really had no control over what they did is likely to be a very difficult one. But if the evidence establishes they had no control over it, I don't see how it can be an act that gives rise to intentionality. I don't think that means, for example, as the questioner asks, that alcoholics can never be intentionally homeless. I think it's about looking at each individual act and what was the position then and there.
Yeah, and I would agree with that. I think you have to be careful, not just from a capacity perspective, but also from an Equality Act perspective, when you make sweeping decisions about particular categories of behaviour need to have certain types of consequences. That you always need to be sure that you have looked at the facts of a specific individual's case. And that also goes for people trying to terminate placements for people who have been found not to have capacity because of their behaviour. You really need to think carefully about doing that and not sort of make sweeping assumptions about this action follows to this consequence.
So 2 more questions. Will you be delivering a webinar re ordinary residence and capacity? I don't know, will we? I guess we could.
Then we can take that one for future discussion.
And then, this is definitely one for you, I would have thought. Can COP get an unwilling executrix to obtain probate? We have a deferred payment agreement registered at land registry, but no one is willing to apply for probate. Oh, this is some care home fee stuff, isn't it? Any views as to how to proceed? This may be relevant to your next webinar. What do you think?
I think it will be relevant to our next webinar. I mean, yes, the Court of Protection could intervene here. I mean, I would imagine that the best thing to do might be just to authorise the signing of that DPA by someone else as being in best interests, or if it's a more complicated situation, getting someone to become a deputy on their behalf. I'm not quite sure about the probate and how that goes in. That sounds like a very specific factual case, but definitely we can think about that for our next session, Justin. Always appreciating ideas.
And there, carrying on through here, I have a question about the Court of Protection. A client of mine who lacks capacity to manage a tenancy agreement. I may not be able to apply for Court of Protection for deputyship as the person does not have an address. No one is willing to house this person because of his threatening behaviours. This sounds like some Court of Protection procedural stuff for you.
Yeah. So you don't need an address, as far as I'm aware, for someone to be a deputy, other than sort of straight procedurally. I think the Court of Protection would be happy to deal with that if it's possibly the public guardian that is making that point. Obviously, the housing. Well, you shouldn't be deprived from having access to these things just because you don't have address. Obviously, as we've seen from a lot of stuff recently around homelessness and access to banking, that can be a problem for banks' procedure. But I think the court of protection would be quite happy to find a way to work around that on P's behalf. I think a lot of these are about money, and so we might call no spoilers on that session, Justin. Otherwise, no one will come.
Carrying on with a few more questions. Who would owe an accommodation duty where someone is considered to lack mental capacity to pay the rent?
Yeah, that's for next time, I think, from my perspective.
Yeah. Pick it up next
Sorry,
time.
everyone.
There you go. Sorry, anonymous attendee, you'll have to come back next time if you want the answer to that one. Let's put that one out of the way. How do you balance who gets housed under homelessness, vulnerable people, and other people who become homeless due to financial life situation? It looks like being vulnerable has more benefits. I mean, you don't have to balance it. Parliament's already done that for you. In very, very simple terms, if you are a person owed the priority in one of the priority need categories, and if you meet the other tests, so you're eligible, which basically is your immigration status, you're meant to be in the country. You're homeless, so you've got nowhere that's reasonable for you to continue to occupy. You aren't intentionally homeless, which means it wasn't your fault that you lost your accommodation. And although it's not actually a test, it's more of a discretionary referral power, and you've got a connection to the local area, then if you pass all those tests, you're owed the Section 1932 duty in England or the Section 75, I think it is, duty in Wales, and you will have to be housed. What you get varies a lot depending on each different local authority. You might get council housing, you might get housing association housing, you might get private sector housing, but you have to be housed. Authorities don't have a lot of leeway on this. If someone meets statutory tests, they have to be helped. And if you don't like that, I'm afraid your answer is take it up with Parliament rather than poor local authorities. Carrying on, in terms of appointing an agent to make an application for housing for an incapacitated person, can the local authority appoint a social worker to do this? So it's important to make clear that at the moment, the law is you can't appoint an agent. That's what Lord Justice Lewison thought the law should be in WB, and it's what whoever wrote the Welsh Code of Guidance thinks the law is. But it's not what the law is according to the House of Lords and the Court of Appeal. At the moment, the law is you have to go and get a deputy appointed from under the mental capacity legislation. Could a social worker be appointed? Don't know, Katharine, this is more your area.
So this is a very important question, I think, because it is something I'm encountering frequently at the moment, which is local authority officers making decisions about finances and other property matters which only deputies can make. And they are doing it in best interests, out of the best intentions, but it's not lawful. And you can expose yourself to some quite significant liability if you do that. So no, setting aside the legal position in respect of homelessness applications, if you do anything on behalf of a protected party in terms of their finances and you don't have the authority, you can get in trouble. So please do apply to the Court of Protection first before you do any of these things. Otherwise, you might find yourself in difficulty later.
So just so I'm clear, if a housing department concludes that a person lacks capacity to make a homelessness application, they should be applying the Mental Capacity Act and assessing capacity and coming to that conclusion. So yes, all questions of capacity, Katharine, see if she agrees with me here. I think all questions of capacity get assessed under the Mental Capacity Act test and the codes of practice under the Mental Capacity Act, looking at Mental Capacity Act case law. If you come to the view they haven't got capacity to understand the outcome of the process. That's what Garlick said we're looking at. It's not to fill in a form, it's to understand the outcome of the process. Then Garlick says they can't make an application at all. And if you want them to go down the Part 7 homelessness route, they need to have a deputy appointed from the Court of Protection. But don't, for my part, I wouldn't take what Garlick or the old pre-Capacity Act cases have to say about capacity as gospel. Capacity, I would say, is now governed by what the Mental Capacity Act says. But Katharine's a real expert here.
Yeah, it absolutely has. Not just the fact that we have the Mental Capacity Act now, which has obviously been in force for sort of 20 years, but we do have very different ideas now about how you deal with people and what capacity looks like. You'll hear a lot more professionals assessing, talking about enablement models, so that sort of supporting understanding and so on. So yeah, I think any case law that's pre-Mental Capacity Act and even over a decade old is very outdated in how it approaches capacity, especially the breaking down of what capacity is into lots of smaller points. Yeah, absolutely, work to be done, I think.
So the last one is a really simple question. Then there's two slides of just things we need to plug at the end, I'm afraid. Last question, will you make the recording available at the end, please? Yes, you will all receive an email probably during the course of tomorrow, I would have thought, with our slides and with a link to a recording of this talk. So if there's anything else you want to go back over, that would be the answer. Right, last two slides and then we'll say goodbye to everyone. Or can you do them, Katharine? Because it hasn't given me control back.
They have disappeared. So Emily, our wonderful slide fairy in marketing, could you please bring the slides back up?
There we are. So we have two books to plug. One is by me and Andrew Arden KC, Homelessness and Allocations, all you could ever want to know about homelessness in both England and Wales. And you see there the slide, you get 20% off if you use that code. So go ahead and buy as many homelessness books as you would like. They make an amazing Christmas present. And then the next slide, Emily, if you could, because ours have given up. Katharine?
So this is Chambers' brand new, published earlier this month, The Law and Practice of Human Rights. So it is about how the Human Rights Act in the UK works, with a lot of reflections on the procedure and also on case law as well, both from Strasbourg to the European Court of Human Rights and the domestic courts. There's a whole section on Article 5. And partly through my involvement, includes a lot of commentary about capacity cases. So I think it would be of a lot of interest, and it's brand new, and you can be one of the first people to have it.
Brilliant. Right, and so I think that brings us to the end. Thank you very much, everyone. If you keep an eye on your emails, as I said, there will be a link to a recording and to our slides. And later on, I think it's now next month, we're going to do a follow-up one of these looking at money issues around capacity. So if that's an area of interest, do join us then. Thank you very much.